come before us this morning is Amanda Posan versus William J. Boyer et al. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you plan to reserve any time, please let me know when you get started. I'm keeping the clock. You can also reference it on the wall over there. The arguments are being recorded, so please keep your voice up, remain behind the podium, and introduce yourself. You should not use the names of children, minors, or victims in your argument. You can refer to them as child, the student, or initials. The judges have read your briefs, and we are ready to proceed when you are.
Question procedure, Your Honor.
Yes.
My client was a minor when this incident occurred. He's now reached majority. May I refer to him as with his Christian name?
We actually have received word that once a minor, always a minor, and
I know it's true in my case.
So if you would refer to your client either by his initial or the student or
Very good.
however.
If I slip, I hope you'll forgive me, Your Honor, but I will try to keep that in mind, I promise.
Thank you.
All right. May it please the court. Counsel, Mr. Lance. Your Honor, for the record, my name is Orville Reed, and I, along with my partner David Hilkert, represent the interests of the claimant in this case, Mrs. Posan and her son. On December 18, 2018, the minor plaintiff was a student in Barberton High School. He was in his sophomore year, first semester of his sophomore year, and he was taking woodworking class. And on the afternoon of December 18, 2018, he was assigned to work with two other students on a radial arm saw. And in the course of that project, work, he put his hand into the blade, too close to the blade, was caught by the blade, and he lost the 4 digits on his dominant left hand. We filed suit against the high school and the board, and also the teacher, Mr. Boyer, claiming, asking for relief under revised code section 2744.02 B4, and also under 2744.03 B5 and 6. The court, after discovery was completed, heard motions for summary judgment and granted defendant's motion for summary judgment, and ruled as a matter of law that the plaintiff had failed to articulate any claim that would afford relief under 2744.02B, as recently visited by the Supreme Court in Doe versus Greenville, or under 2744.03 B5 and 6, as discussed by the court in Anderson versus the City of Massillon. So, having said that no reasonable person could draw the inference of negligence that would permit recovery under 2744.02 or recklessness under 2744.03, I would like to go over those facts with you to determine, suggest to you that a reasonable person, one reasonable person, could perhaps draw reference, an inference of negligence and or recklessness. On December 18, 2018, my client, Mrs. Posan's son, was 15 years of age. He would turn 16 on February 23rd of the following year. But at the time of this incident, he was 15 years old. In his affidavit, he represented that, in fact, he had never seen a power saw, had never seen a radial arm saw prior to his taking this class of woodworking. He was in his first semester of his sophomore year. Over the course of the semester, from late August or early September of 2018, he had approximately 10 to 15 minutes of supervised time at the radial arm saw with his instructor, Mr. Boyer. That was the extent of his experience with the radial arm saw.
Have you had any written tests on how to use SAR?
They did a before the work started, Judge. He did, in fact, they did give a test, and just a test, and it did involve, in fact, this piece of equipment. Right. So he had spent approximately 10 minutes, was unfamiliar with this equipment, On the day in question, he was asked by Mr. Boyer, the teacher, the instructor who was working at Barberton High School, to cut up some wood because it had to be cut up to clean up the classroom. In other words, he was asking these boys, and there were three of them. It was Mr. Well, I won't get into their names. There were three boys, three students who were asked to do this. They were all sophomores, all roughly and approximately the same age. So essentially what they were doing was not working on a project. They weren't building a birdhouse or a bookshelf or bookends. What they were doing was cutting up wood, which would have been Mr. Boyer's job, but they were doing it for him. So he spent time with them, and I don't know whether you've had an opportunity to look at the video. It shows him, in fact, working with the boys, showing them for several minutes what to do. He then leaves the area, so they are left unattended to work on this work on this project.
Council, before you go any further, I just thought of a question whenever you were arguing. With the cleanup, was there any type of policy in regard to, that they were allowed to use the students to clean up? I mean, like for instance, when you play baseball or you play basketball or whatever, you usually stay afterwards if you're the home team and clean up, the baseball field.
Right.
So that's just standard procedure. And plus, I would assume too, I don't know if there's any evidence about this, but that if part of your instruction has to be in regard to how to clean up the saws and the different tools that you're using in woodchuck. No.
Your Honor, the fact of the matter is that I think the testimony was from the high school principal and also Mr. Boyer, that in fact everybody was responsible for cleaning up their workstation, whatever they were working on that day. I think my point was that if in fact the bell rang, the students would leave and Mr. Boyer would be responsible for cleaning up. But in fact, the students understood that they would help cleaning up. The instructions were to cut up the wood. The wood was then placed in a big barrel, and students and teachers, professors, and administration could take the wood home and use it for starter in the fireplace. So the boys are left, those three young men are left there unattended, and it is during this time that Ted comes in contact with the blade. The radio alarm saw the blade moves at a speed of approximately 60 miles per hour. It's a formidable piece of equipment, and it cuts through wood, and it chews up hands and fingers, and it took off 4 of the digits on his left hand, his dominant hand. 4 of the fingers were then sewed on by Dr. Engel, and of that, 3 of them took, in the sense that they were put back on. 1 finger totally failed. They had to then surgically amputate that. But the fingers were useless from a practical standpoint. But aesthetically, Dr.
Council, there was this saw stop program, the safety program that exists.
Yeah.
And I understand it was not used. Did your experts comment upon the use of saw stop at all?
I don't think the experts addressed the saw stop, Your Honor, precisely, but I'd like to address it. And that is the saw stop that was available but not used has a feature that when it senses the moisture in the skin, it stops, it shuts down.
And that solely then at the discretion of Mr. Boyer to turn the saw stop on, or was there a policy on how that was supposed to be done?
It appears, Your Honor, from the testimony of the students, that in fact, the only people that used the saw stop were Mr. Boyer himself or the students under his close supervision. No one went over and used the saw stop. And the reason for that is because if the saw stop is activated and it reacts like it's supposed to, as the patent material provides, it's going to shut down, and the cartridge has to be replaced at a cost of approximately $100.
And Mr. Boyer testified, when you say the reason, Mr. Boyer testified that was his reason for not using saw stop, or that's inference drawn from that?
That is the inference drawn from the testimony of the students, Your Honor. It did not come from Mr. Boyer. But in point of fact, I don't think there's any dispute about what they said, and that is that, in fact, only he or the students under his close supervision could could use the saw stop. Your Honor, I forgot to reserve time. Could I reserve 2 or 3 minutes? I'll let.
Which?
Give me 2.
Okay, thank you.
Tie me down, Your Honor. My goodness. And I don't know where I am now.
6.
Okay, thank you. Thank you very much. All right, so let me talk about the condition of the radio alarm saw. And that is, it was inadequately guarded. There should have been an upper guard and a lower guard. And the fact of the matter is, both the high school, the administration, as well as Mr. Boyer, didn't care what OSHA said. It didn't care. And I think that is a sort of indifference to which recklessness speaks. You can talk about a conscious disregard or indifference to a known risk or an obvious risk, harm to another person. And I cannot believe that this is not the essence of indifference. They don't care what OSHA says. Now, admittedly, OSHA doesn't apply in the classroom. It doesn't. It applies in the workplace. But the fact of the matter is, you would expect that a school that deals with youngsters, 14, 15, and 16 years old that are working on this machine, would be afforded the safest type of equipment. It was not. This machine lacked safety measures, including the lower.
Is there anything like OSHA, and I think it was argued by the school board, like OSHA that applies to the school board that would replace OSHA? Is there any requirement for safety standards for schools?
Your Honor, I would assume that it applies to all the teachers who work there. In other words, it's OSHA for them, but the fact of the matter is, the students, we don't care. OSHA doesn't apply to us. We don't care what the standard is. We don't have to use it in the classroom.
Was there any testimony from in Mr. Boyer's deposition that would indicate that he believed that the saw without the bottom guard was inherently dangerous or defective?
No, Your Honor, no, he didn't concede that. Yeah. As a matter of fact, he basically felt, as long as you do what I told you, there's no reason to have guards on. If you just do what I told you to do, there's no reason for the lower guard. I mean, you hear that all the time, in the workplace. Employers saying, well, if they just did what I said. But that's why we have OSHA. People make mistakes. People do act inadvertently at times, and people do experience problems. He leaves the room area. The boys are left on their own, and you can see from the video that there was some horseplay that was going on. That didn't involve my client. It involved the other boys. And Mr. Boyer testified that had he seen that, but he didn't see it because he wasn't in the room. He wasn't watching these kids, even though he's claimed his policy was not to let the children use power tools when he was out of the room. The fact of the matter is, he was totally unaware of what was going on, and he testified that if he had seen this, he didn't see this for until 2.5 years later, that there was this horseplay going on, he would have shut it down. I think my time is just about up. It's not up. And I thank you for your time this morning.
Thank you, Counsel.
May it please the court, Mr. Reed and Mr. Hilker. My name is Attorney Jim Lyons. I'm here today on behalf of the appellees. At the outset, we agree with the appellant that this court applies a de novo standard of review. In other words, this court acts itself as the trial court as to determine whether or not summary judgment was appropriate. The first issue that should be addressed is there any evidence of negligence whatsoever? And appellees submit to the court that the entirety of the evidence is that there was no evidence that Mr. Boyer was negligent, and because there was no evidence that Mr. Boyer was negligent, there can be no liability, no consideration of liability for the high school or the board.
So you're saying that it doesn't even get past the negligence standard. So leaving students in a classroom with a sharp tool that goes 60 miles an hour and tells them to cut wood, it's not maybe negligent?
Your Honor, first of all of the evidence before the court in the form of the affidavits of Mr. Boyer, Mr. Muir, and Mr. Farron were that Mr. Boyer met the standard of care of a high school teacher on that particular day. There is no
What do they say the standard of care was for a high school student, for a high school teacher in this circumstance? Ordinary care, what was their standard?
It was that of a reasonably prudent high school teacher. The experts of the appellant were not competent to qualify, to testify, or opine on that standard. They did not meet the experience level of a Ohio high school teacher. All of
Did
the
they
evidence.
attempt to opine on that, or was the expert testimony more on the use of the machine as opposed to the standard of duty of care for a teacher?
I believe, in my recollection, is that it pertained more to the machine, Your Honor.
Counsel, did any of the affidavits or depositions that were conducted or the affidavits presented as to Mr. Boyer meeting the standard of care, were they from teachers or administrators that worked with dangerous equipment as a teacher?
Your Honor, the affidavits of the administrator were familiar with the facts.
Well, that's not what I asked you. I said, did they say that they had experience working with equipment as a teacher? Because it seems to me like there's a difference in regard to supervision if you're supervising a group of 5-year-olds as opposed to a group of 15-year-olds. There's a difference if you're supervising kids in gym class as opposed to botany class. So it seems to me like there would be a difference between supervising kids and maybe a different standard of care for somebody that's involved in the use of equipment that could be very dangerous.
Certainly, Mr. Boyer was familiar with that, and the experts of the appellant were not. The appellants place heavy reliance upon OSHA, and they cite the Supreme Court case of Anderson. And as Anderson speaks of a safety statute enacted for the benefit of the public at large, OSHA is not. OSHA pertains to the employer-employee relationship. And as a matter of fact, in answer to this court's earlier question to Mr. Reed, by definition, OSHA does not apply to the state or its political subdivisions. There is absolutely no reason that Mr. Boyer or any of the administrators would have any knowledge of OSHA. And the evidence was uncontradicted that had Mr. Boyer's safety rules and regulations been followed, this accident would not have happened. The appellant himself testified to that in that regard.
So you're saying that OSHA didn't apply even to the teachers themselves in handling the equipment?
By definition, Congress, OSHA does not apply to the state or its political subdivisions. Section 3. Even if the court were to consider the issue of negligence, then we must move on to the issue of whether there is any evidence of recklessness. And we agree with the appellants that the correct standard of recklessness is stated in the Anderson opinion. And that is defined as a conscious disregard or indifference to a known or obvious risk of harm that is unreasonable under circumstances and substantially greater than negligence. Mr. Boyer, by all accounts, spent the first numerous weeks of that semester teaching students on how to safely operate equipment. Both the students and their parents had to sign off that they understood the safety protocol. And as I mentioned, APV testified that had he followed those safety instructions from Mr. Boyer, this accident would not have happened.
Is it Mr. Boyer's sole decision to use the saw stop safety procedure?
But the saw stop, Your Honor, it is a separate saw. And it has a different safety guard than this saw.
And so it did not this saw stop would not have worked on this particular saw?
On this particular cut, I believe it may have, but it was his decision to use the radial arm saw. And all of the case law indicates that teachers are offered a wide range of discretion. There are numerous cases that a teacher does not have to constantly supervise his students.
Did Mr. Boyer say under what circumstances he used the saw stop feature on this particular saw?
Your Honor, I cannot recall that testimony.
Did he use it when he was training the students?
I believe the students were trained on the saw stop, and I do recall one of the students who was deposed testified that he had used the saw stop saw. But as I've indicated, there's no evidence that had Mr. Boyer's safety rules and regulations been followed, this accident would not have happened.
Did anybody testify or give any information by affidavit as to why the stall, that's a
The
very
saw
hard
stop.
thing to say, saw stop even existed?
Well, it was
wasn't
another,
replaced.
I believe the evidence was that it was another piece of equipment, and that there were multiple pieces of equipment that the students were trained on.
Right, but what I'm saying is, if it performed the same cuts and was safer, trying to figure out why wasn't it utilized?
I don't recall any specific evidence with respect to why the radial saw was used on the day of the accident.
In asking the same question as the plaintiffs, did their experts or any expert testify or have affidavits indicating when you would use saw stop?
Not that I recall. One of the cases cited by the appellant is the Gooden case out of the 4th District, and is the the Sharp case out of the 4th District. And as the appellants pointed out, the Sharp case compares and contrasts numerous decisions that the lower courts of appeals have addressed. And one of those decisions is the Gooden case, I believe, also out of the 4th District. And that case literally is almost on all fours with this case. In that case, the students were trained extensively, received safety training on how to operate this saw, which also did not have a guard. And in that case, summary judgment was affirmed. And in this case, summary judgment likewise should be affirmed. And finally, even if there was evidence of negligence, then as to the board, the court would have to consider 274403, 83, and 85, both providing a reinstatement of immunity, unless there was evidence of recklessness. And I submit to the court, there is absolutely no evidence of recklessness before this court.
So when under, if I understand it, the school board showed that Mr. Boyer was negligent, and this piece of property or this piece of equipment was defective, would that be sufficient to show liability on part of the board?
I'm sorry, Your Honor, what was the first part of your question?
Okay. So going to 274402B4. If the school board showed that Mr. Boyer was negligent, and in fact that there was fiddle with the defects in this machine, that would be liability for the school, unless it met one of the exceptions under 274403.
Your Honor, as to the first prong of the test, there must be both negligence and evidence of a defect.
Well, I understand if we were to find, or say the trial court erred in saying no negligence, and there was no defect, that would be liability unless it met one of the, under the factors of 274403.
I agree with that. Okay. And we also understand that the Doe versus Greenville case was subsequently decided by the Supreme Court in December of last year, after this case had been appealed to this court. And it would seem to suggest, or it says, at least as I understand, that court's opinion is a defect, could be evidence of a defect under the applicable test. But first, before you even may consider that, you must first find that an employee was negligent. And as I said, I do not believe there is any appropriate admissible evidence of negligence before the court.
Counsel, before you conclude, I just wanted to go over one other area, and that is the trial court's use of the perverse disregard of a known risk. Now, you seem to agree with opposing counsel that the court should have been looking at Anderson in regard to the test for recklessness. So what are we to do with that?
Sitting in de novo, the court can apply the Anderson standard, and the result is still the same. There is no evidence.
And we do sit de novo, but we also sit as a court of review in the respect that we don't make a decision the first time if the decision is wrong. So how would this be different? I mean, the application of the law is wrong.
I think if you apply Anderson to the facts of this case, there is no evidence of recklessness necessary to create a factual issue in that respect. I think the evidence is clear. Mr. Boyer was very well aware of the risk and took extraordinary measures to teach these students safety. And the fact that he may have walked out is within his discretion. The courts of Ohio have always granted wide discretion to teachers and administrators. And on behalf of the athletes, I would request that this court affirm the correct decision of the trial court. Thank you.
Thank you, counsel.
Thank you. Let me say that, first of all, Your Honor, if I may just address your request for Judge Carter, and that is, I think this situation is actually controlled by App.No, a recent decision by, I think Judge Titos, who wrote that opinion, and basically alluded to the fact that if, in fact, the wrong standard is used by the trial court, it is not this court's function to say, okay, now we're going to apply our standard, which I think was the correct standard. And I think that it has to go back for review. I would hope that you will reverse the decision, besides send it back for that reason. But nevertheless, Mr. Lyons made a comment that the teacher went to extraordinary steps, took extraordinary steps to protect the students, not just my client, but all the clients in the use of this piece of equipment. They took all the extraordinary steps except trying to figure out what OSHA would require for adults in the workplace. Why wouldn't you do that? And the other thing is that the indifference of the people toward them. They just had no interest in knowing. Well, here we have a place of higher education, high school, okay. And the people that run the high school have no interest in what is the safest thing to do. But to answer your question, Your Honor, saw stop is a separate saw. And in fact, it is considered to be the state of the art. But the only people that used it were the teacher and the students who were under his direct supervision. This was not safe at saw stop. I want to say this. Juries, we ask juries to do a lot of things. We ask them to sit in judgment of doctors who do brain surgery. They don't have to go to medical school to be on the jury, and they figure cases out. You don't. You can have a jury decide whether or not household products that have been used for 50 years throughout this country contain carcinogenics based upon test results from this testing company or test results from this company, and they've never taken a day of organic chemistry. They decide those cases. And I think a jury can decide this case as to whether or not, under all the circumstances extant here, they can determine whether or not these people were negligent or reckless, and they can do it, and there is evidence to support it. And I would urge this court, again, I think Bevilacqua does control, but I would ask this court to reverse the decision and find that there is evidence that some reasonable person out in this fair land could find that this teacher was negligent and this teacher was reckless. Thank you.
Thank you. Thank you both for your presentations today. The court will take the matter under advisement. We will issue a decision which will be mailed by the clerk of courts to all parties to this appeal. It will also be posted on the House Supreme Court website. We are adjourned until